Good afternoon, and welcome to this afternoon's presentation of a webinar by Beresford Booth's Estate Planning and Probate Group. I'm Per Oscarsson, a member of the Estate Planning and Probate Group here at the firm. And joining me today is Sarah Smith, also part of the Estate Planning and Probate Group. Our topic today is, do I need a will? I would like to remind you that we're providing this information just as information for you only. It's not legal opinion or legal advice. I'll be talking about kind of what happens if you don't have a will, and Sarah will be dealing with different types of questions involving wills. Would also like to point out that we'll be talking primarily on Washington law, and keep in mind that the law of states will vary. Some states may be exactly the same as Washington, some may not, in various aspects of what we're talking about. So it is important to keep in mind that there is or very well may be a difference between the law of the state of Washington and the law of some other state. So I'm going to talk, as I said, about what happens when you don't have a will. It's known as intestacy. The big difference really is control of what you want to have done when you pass away. If you are comfortable with the process for administering your estate when you die, then you may feel, I don't need a will. But there are various aspects of that you may not like. And when I say control, it's things like in a will, for example, you can identify your personal representative. If you do not have a will, who has the authority or the right to administer your estate? Well, Washington state law provides a list, and it's in an order of priority of what type of people could serve as your personal representative. And you kind of have to go through the list. For example, a surviving spouse or a surviving state registered domestic partner. We won't get into the details of the state registered domestic partner today, but suffice it to say that either one of those people would have the first priority. Then it falls down the list to kids. But it would be the children, all of whom could serve, or some could decline to serve and have only one of the children serve. But again, that's controlled by statute. Another difference with intestacy is that you don't control who receives what kind of property that you may have or how they receive it. One of the things that we look at also is in determining intestacy, or what happens in intestacy, is what's your status at the time of your death? Were you married, or did you have a state registered domestic partner? Another thing we look at is what type of property do you have? If you're married or have a state registered domestic partner, you may have community property, and you may or may not have separate property, because upon death, those types of property are treated differently under state law. For example, community property, everything goes to the surviving spouse or state registered domestic partner. In the case of separate property, unfortunately, the answer is it depends, because it depends upon who survives you. And although we may often talk about our heirs and say, oh, so-and-so is my heir. Well, that may or may not be true, because we cannot determine who our heirs are until we die. Or maybe I should say, our heirs cannot be determined, since we will have no ability to do so, but our heirs cannot be determined until we die. And the state law doesn't really tell you individually who receives it, whatever property you may have or whatever interest you may have. It tells you a class of people or various classes. And so you kind of have to go through at the time of death, who are your relatives? Because we look at issue, would be children, grandchildren. We may go to ancestors. We may have to go back to maybe their parents received whatever we had. Potentially brothers and sisters, aunts and uncles, nieces and nephews, potentially grandparents. So it's very important, if someone dies without a will, that we determine who the people are that potentially would receive something and what is their relationship to the deceased individual. I've heard the question several times, well, I have or I want a trust set up. Why do I need a will? Well, and Sarah may get into this a little bit as well. If you don't get everything put into the trust before death and you die without a will, the intestacy laws will apply to whatever property never made its way into the trust. So we still have to deal with potentially with an administration of intestate assets, and we have to go back to the same rules. I would say probably 80% of the administration of an intestacy estate would be about the same as a testate estate or estate with a will. Those processes are pretty much the same. So, Sarah, I'm going to throw it over to you and have you deal with wills.
Thank you very much. So as Per was just discussing, we do have these intestacy laws that are in place to step in if you don't have a will. Legislatures got all together, had to think and said something to the effect of, what would the average person want? What structure can we create that will effectuate the wishes of as many people as possible? Effectively trying to create a one-size-fits-all system. But as I'm sure you can appreciate, very rarely does one size truly fit all. So the will is important to allow you to customize your plan according to your wishes, and make sure that what happens is what fits for you and your family. Important examples of these include the obvious distribution of your assets. Legislation says we think that you would want your community property to go to your spouse, and we think that you would want to focus on providing for your spouse and your children, and we'll deal with the separate property that way, and down the line it goes. But that doesn't leave any space if you had wanted to leave money to a charity or a church or a synagogue or some other entity that is important to you. Additionally, it doesn't contemplate that while you may love all of your children equally, very likely they don't have equal needs. You may want to provide more for a particular child who is having certain struggles, or perhaps has chosen to be a teacher and give to the world that way, as opposed to their sibling, which became a neurosurgeon. Different lifestyles, and may need, or you may want to give them different types of support under the circumstances. You may also have minors or individuals with special needs, or some other situation where a more thoughtful look at how you want to leave that gift. Because of course, it's not just who or the amount, but it's also how. Under the intestacy rules, when you give a gift to an adult, it goes right in their pocket and they can spend it however they want. Call me a cynic, but I don't know many 18-year-olds who really need to have that kind of pocket change burning a hole in their pocket. You may find it very valuable instead to do more specific planning that would create potentially a testamentary trust to hold those funds until they've reached an elder age, maybe 35, maybe 40. Maybe you want to control how assets are distributed even beyond that. There's a large sum, or there's a precious piece of property you don't want to be sold, or any number of circumstances. Or perhaps we don't need a trust and we do a UTMA designation and say, we're gonna have the custodian handle these funds for the kid until they reach 21, all the way up to 25, in fact. You don't have the same expense and hassle as you would with a guardianship or a trust, but you still have a little bit of extra, let's wait for their brain to finish cooking, and then they can have full access. So when we're looking again, yes, the intestacy rules are there and they're helpful and they serve an important purpose, but the customization that comes from designating a will cannot be stressed and is very important. And as Per noted, even if you have a trust, particularly a living trust, you are still going to need a will, either because there's property that you chose not to put in the trust, or frankly, more often, property that you did forget to put in. And so that will can take care of those assets and make sure it ends up in the trust as you originally intended or is distributed otherwise. And there's a lot of discussion about assets, but really the important thing here, of course, is your family, is the people. So one of the very important things that you can do in your will is nominate a guardian for your minor children, because the courts will generally honor that nomination unless there's a very good reason not to. So if you know that there is a godparent, a friend, a specific family member, etc., who you want to have the care and power to take care of your child or children in the event that both you and the other parent are not there to handle that role, this is where you can do that and make sure that your wishes are heard. Otherwise, the court's going to make the best decision that they can. And the opportunity for conflict within the remaining family, if there's a disagreement about who that person should be, can be expensive and unpleasant, as conflict typically is. And of course, you can nominate the executor of your will, the person that you want to control and follow the instructions that you have laid out. But the important thing to remember is this is the document that you use to create a customized plan that finishes the thing that you've been doing your entire life, which is taking care of your family in the way that you think is best. Not necessarily helpful for everybody, but if you have a success problem, you have a large enough estate where taxes might be a problem, this is a great place to do some final tax planning, shall we say. And most important of all, we've asked the question, do you need a will? And the answer is probably. But you do need estate planning because we also want to look at powers of attorney and documents that help you during your lifetime. So if at the end of this lecture you say to yourself, I don't think I need a will, I think leaving it according to these intestacy laws, that fits me just fine. That's wonderful. But it's still worth a conversation to make sure that you have these other pieces in place that will take care of you during your lifetime as well. And forgive me, I could wax on for hours. Do we have any questions? Doesn't look like.
I don't think so. Thank you, Sarah. So, why use a lawyer in your planning? Well, we've all seen there are online forms available, but they may not be tailored specifically to our state. That's possible. I don't know if there may be advisors available if you go online to do a document, but I suspect that they may not have that kind of resource available for you. So that's one thing to be concerned about. Another thing in talking with an attorney, as Sarah mentioned, is there may be some tax planning issues because your estate may be potentially subject to estate tax, and whether imposed by the state of Washington or imposed by the federal government. And there are some planning opportunities in a will that can reduce or potentially even eliminate the liability for estate tax, and that's something that's definitely worthwhile. It's also something a lawyer can give you different options. There may be some things that you want to have in a will, trusts, for example, whether or not necessary or appropriate for estate planning purposes, but also, as Sarah alluded to, there may be a reason for having a trust in your will. One of the ones that comes to mind is a special needs trust. Someone who at some point in their life either is on a needs-based government benefit or may at some point need to try and qualify for a needs-based government benefit. A special needs trust, even set up in a will for the benefit of that individual, can help them because the assets in that trust can be used not to replace the government benefits, but to supplement them. Because some of those benefits may not be usable for certain items, whereas items or property in the trust could be. I think having a lawyer help with planning is also helpful because of other issues that they may spot just in talking with you and going through what kind of assets you have, what your what your wishes are that you may not have considered. There may be things, for example, in a blended family that could have a number of issues that probably don't come up if you're not talking with an attorney about how that might affect your planning. And I think too that it's important not to try and rely on doing it yourself. This is not, this is certainly not the attorney's full employment program, but there are a number of things that can happen with a will. For example, if you make changes to a will, the same will you signed 5 years ago, maybe you make some handwritten changes to them, those are not going to be effective. And it could potentially, depending upon the nature and extent of those changes, could invalidate the will entirely.
Mm-hmm.
And then we're back to the intestacy situation, because now it says if you died without a will, because effectively you may have done that to yourself. And so having a lawyer that can advise you and prepare the appropriate documents and supervise the appropriate execution or signing of those documents. For example, in Washington, we have to have 2 witnesses, preferably not witnesses who are receiving something under the will, but having 2 witnesses actually witness the signing of the will. So with that, unless you have anything further, Sarah.
No, but that's a great point. I've seen a handful of wills that people have done. They've printed a form off the internet, or they've tried to do something that's handwritten, and making sure that those formalities, those details are followed. It's incredibly important, because you can think that you have a valid will when in fact you don't. And trying to work around that, even when it's possible, is incredibly difficult.
Yes, absolutely.
Working with someone who can be interactive and work with you with your situation, the nuance, to understand and suggest things that perhaps you hadn't thought of, or that a computer system is just not complex enough to anticipate. It's very important.
Yeah. Well, thank you all for joining us. We hope you'll join our Beresford Booth webinar next week, and enjoy the rest of the day, and don't get too hot. Thank you.